On the first day of 2024, we have a very special guest, Chief Justice of India, Justice D.Y. Chandrachud. Sir, hearty welcome to PTI and also wishing you and your family a very happy new year, sir.
Thank you very much, Etasham, and it's a pleasure to be with you this morning. Happy New Year to you, to everyone in PTI, and to your families.
Thank you so much, sir. As we ring into the new year, how do you see, when you look back, how do you see 2023 in terms of the performance of courts all over India and failures and successes of the courts all over India and the performance of judiciary as a whole, because there has been a lot of changes in the last 1 year. How do you see that?
Etasham, we were coming out of the shadow of COVID. After COVID descended, it was a very difficult time for the Indian judiciary. We were able to cope because of the sound technological infrastructure which our judiciary has, and our performance in that sense, even during the COVID times, was unprecedented. But at the same time, COVID did bring in very serious challenges in terms of staff, in terms of the lawyers, for the judges themselves, because families were involved. It led to so many different issues which we had to face within the judiciary. But the last year was a remarkable year, I feel, for the Indian judiciary, because we have taken several new steps to making justice more inclusive, to promoting access to justice. Now, typically, when you look at a court, the public, the citizens view the courts from the perspective of the output, the judgments. But equally, they look at the process which is going on in the courts, because that process has to be friendly enough for citizens, it has to promote access, and it should not be a barrier to any citizen across the nation. We have taken some very unique initiatives in the last year. They are all designed to ensure enhanced accessibility and transparency to the Indian judiciary. Coming to the Supreme Court, for example, we have started live streaming of important cases emanating from the constitution benches. And I believe that live streaming is one signal achievement of our Indian judiciary over the course of the last year, which is intended to take the work of the judiciary to the homes and the hearts of people. The Supreme Court has been regarded as a people's court, and I think there can be no better initiative for us to continue to be a people's court than to ensure that we live stream our proceedings so that people understand the nature of the work which is carried on in the courts. They understand the seriousness with which every individual case, whether it's an important constitutional case or a small case involving somebody's pension, is taken up by the court. So live streaming has been a very important initiative. The second important initiative which I would like to mention is the ESR Portal. There are about 36,000 judgments of the Supreme Court since independence, since the court was established. Now, all these judgments are recorded in English, which is the official language of the Supreme Court. But not all our citizens understand English, and legal English at that. So one of the very important initiatives which we adopted was first to digitize all these judgments, place them in the public realm, and ensure that citizens have free access to these judgments through the electronic Supreme Court reports. But we haven't stopped at that. We have been using artificial intelligence for the purpose of translating the judgments of the Supreme Court, machine-assisted translation, as a consequence of which, as of date, as we speak, about 23,500 judgments of the Supreme Court have already been translated into Hindi, and they are part of the ESR Portal, so that just as you have a free text search portal in the English version of the ESR, any citizen can access judgments in terms of the date of the decision, the name of the judge, the subject of the decision, so on and so forth, on the basis of a variety of search parameters. And our effort is to translate all our judgments into every one of the recognized languages, recognized in the sense constitutionally recognized languages, and we are moving on that in a very rapid way. Apart from this, The court has been taking very important initiatives for ensuring physical accessibility of our premises. I had constituted a committee chaired by one of my colleagues, Justice Ravindra Bhatt, to conduct an accessibility audit of the Supreme Court of India. And the accessibility audit has revealed very important steps which we have to take to ensure that people, regardless of physical disability, are not denied access in the true sense of the term to the Supreme Court. We have been trying to integrate technology into the work of our courtrooms. The first 3 courts in the Supreme Court have been equipped completely with 120-inch screens so that people from across the country can watch proceedings, can address proceedings. Lawyers from across the country, parties in person, can address us from across the country. They can submit documents digitally. In fact, my court, as the Chief Justice of India, is completely paperless. The judges don't use paper, and I encourage lawyers not to use paper. All our files are delivered to us digitally, and we are completely off paper. We are now expanding that to court number 4 and court number 5 in another fortnight. The same facilities would be available in court numbers 4 and 5. If you wanted to come to the Supreme Court and you needed a pass, you had to come and wait in a line to get a physical pass. That has been now replaced by the Suswagatam portal, as we call it, as a result of which even the passes for entry into the Supreme Court have been made digital. So a lot of new initiatives on the technology front which are being adopted not just by the Supreme Court but by the High Courts. There is virtually a veritable competition now among the High Courts.
Delhi High Court especially.
Yes, Delhi High Court, a lot of High Courts now, Karnataka, Kerala, Tamil Nadu, Madhya Pradesh, Punjab and Haryana. You just name the High Courts and they are doing something new. And I have invitations almost by the week to release a new initiative of the High Courts for the citizenry at large. One of the problems which we found was about the communication of bail orders of the Supreme Court down to the jails. Because it is not enough that we are extremely alert about the need to grant bail in appropriate cases, but these orders must reach the under-trials or convicts, many of them who are under-resourced. They don't have adequate literacy. They do not have necessarily access to legal aid. The Supreme Court has developed a module called FASTER, and now we are implementing FASTER 2.0, which uses blockchain technology, so that through the use of blockchain technology, the orders are authenticated. That ensures that the orders cannot be fabricated and then put out onto the public realm. And we are ensuring that we have control over all subsequent steps which are taken to implement the orders. So the district judge in one of the districts in India who has to pass the bail order consequent upon the Supreme Court granting bail and impose requisite conditions, does that on time. We can ensure that the jailer in one of the jails across India has actually delivered the order. They will report back onto the portal, and all this is capable of being monitored. One of the initiatives which we adopted in the last year to promote gender sensitivity was to come out on a gender handbook. The idea of the gender handbook, Etisham, is that we, in our legal discourse, we must be more attuned to the need to maintain gender sensitivity, so that certain phrases that were routinely used, words which were used in legal discourse, are no longer acceptable. Why are they no longer acceptable? So through this gender handbook, which we are using as a training module across India for training judges, lawyers, paralegal staff, is something which we are working on and which we have already put out into the public realm. We have come out with guidelines for the framing of written submissions. Litigation is becoming very complex. It's becoming complex partly as a result of the economic complexities of our times. Many of the new laws that Parliament has enacted are regulatory laws, like the Insolvency and Bankruptcy Code. This gives rise to a lot of complexity of litigation, and that also reflects in the volume of the paper books which we have to deal with. Today, a paper book of say 20,000 pages is not unique, it's normal. That's the new normal that judges have to deal with. 30,000 pages. When we dealt with the Ayodhya case, for instance, 30,000 plus was the size of the paper book, the documents. When we dealt with Article 370 recently, we crossed that as well. Now, how do we equip judges to ensure that they don't lose sight of important parts of the paper book? So we have put into place a standard operating procedure for the filing of written submissions, for filing of joint compilations by lawyers. All this to ensure that the whole process of presentation of cases is streamlined, that there should not be an element of ambush in the course of legal arguments. Everything should be transparent. So my idea about incorporating technology as part of the judicial process is to make this truly a citizen-centric judiciary, a judiciary which is responsive to the needs of our citizens. So the object of incorporating technology is not to set apart the court from the citizens. It is to enhance transparency, bring out greater participation of citizens in the work of the courts, and to ensure ultimately that we are responsive to the needs of our citizens.
So, as far as the pendency of cases is concerned, it has always been a big cause of concern. So, in 2023, we saw that Supreme Court disposed of a record number of cases. How was that possible? What extra efforts were made for that?
Well, to give you the figures, we disposed of 52,191 cases from 1st of January to 15th of December 2023. And this exceeded our registered filing, which was 49,191, which showcases in a certain way effective case management. We did that at different levels. First and foremost, we did that in terms of streamlined case processing. In the time which is taken between the point when a case is actually lodged in the registry to the point of time at which the case comes up for actual hearing before the court for the first time, that period has been reduced from 7 days or even more, it was sometimes much more than even 7 days, to 5 days or less. We have prioritized certain types of cases, for instance, cases involving bail, cases involving demolition, cases which are extremely urgent, so that those cases can be processed even within a day and can be listed before the court. We have also put into place a procedure by which there is swift handling of certain types of cases, bail, habeas corpus, eviction, anticipatory bail. These cases can be processed and are processed, generally speaking, even in one day. So we have really first and foremost focused on the time which is taken from filing to the listing of a case for hearing before the court. The second important step which we took was for having specialized benches for adjudication of cases. The age in which we live today, and this is not something which is unique to the law, it's across the board. It's an age of specialization. And I thought that it's important that we must have judges with domain expertise hearing certain types of cases which require domain knowledge and domain expertise. So we have, for instance, just to give you one example, 392 Insolvency and Bankruptcy Act cases were resolved in a single judgment. I've constituted 3-judge bench special benches with almost 166 sittings addressing crucial matters and references. The areas where we have had specialized benches are land acquisition. Now, land acquisition cases deal with citizens' rights. Somebody whose land is acquired is looking for the grant of compensation, and it's not a sole individual. A single notification would cover hundreds, if not thousands, of our citizens. So, listing land acquisition cases in the Supreme Court not only ensures that these cases are disposed of by the Supreme Court, but they have a fallout in the High Courts, because then those decisions give guidance to the High Courts on what the court is deciding in relation to a particular notification or in relation to a particular issue. Apart from land acquisition cases, cases involving compensation. These are basically cases involving motor accidents where citizens across India are affected by motor accidents. Sometimes where a death takes place, their legal heirs are waiting for the grant of compensation by the insurance companies. So we had a specialized bench for compensation cases. We've had a specialized bench for direct tax cases. We have had specialized benches for indirect tax cases, particularly in the context of the GST. We also have specialized benches for insolvency and bankruptcy, the commercial cases that we have today. So setting up domain expert benches where judges who have specialized knowledge in that branch would work on those cases has been really one of the key factors in speeding up disposals. So, but apart from this, we have been focusing on, say, criminal cases. Criminal cases, as you know, are the largest single source of filings in the Supreme Court. So criminal cases are dealt with almost by all judges. But within criminal cases, we have judges dealing with cases in which they have expertise. For instance, there were death references which were pending before the Supreme Court. And death references have to be disposed of at the earliest because somebody in jail under the shadow of the award of the death penalty, you can imagine the psychological impact on that person. There's a societal interest involved as well. So I requested one of my very senior colleagues, Justice Bhushan Gavai, to take up the death references. Death references go to a combination of 3 judges, and that has resulted in the disposal of a large number of cases involving the award of the death penalty as well. So these are some of the steps which we have taken. Greater use of technology in the process, and this is going to be a mission which I'm sure will continue for the future.
Hopefully. So, access for justice, you have been speaking about it since long, ever since you came to Supreme Court. So, how do you think this can be made possible that every individual, every citizen of the country feels closer to judiciary and reposes faith on the system? How do you think, what are the challenges? How can it be made possible?
Well, let me begin by saying that the number of cases which are filed every year in our courts, whether it's the district courts, the high courts, or the Supreme Courts, is a clear index of the faith that common citizens have in the work of the judiciary. Because the kind of work which our courts do is virtually unprecedented in any other part of the world. For instance, the Supreme Court's doors are open to every common citizen. Very few Supreme Courts across the world do the kind of caseload which we handle. And I dare say the same thing is true about the high courts as well as of the district judiciary. The district judiciary is a very important source of concern for me as Chief Justice of India, in the sense that the first point of engagement of a citizen is with the district judiciary. The citizen doesn't go usually to the Supreme Court as a matter of first resort, but to the district judiciary, whether it's for a stay in a civil matter, anticipatory bail, or a variety of other issues which face common citizens. So it's important for us to focus on the district judiciary in terms of its infrastructure, in terms of filling up vacancies, in terms of training judges, and in putting into place better case management systems for handling the work of the district judiciary. And work is going on a war footing on each of these issues. We are looking very closely at the infrastructure of the district judiciary. There's a case which is pending before the Supreme Court, namely the Malik Mazhar Sultan case, where successive Chief Justices have been monitoring the work in the states in terms of upgrading the infrastructure of the Indian judiciary, the district judiciary, filling up vacancies, because we cannot have vacant posts in the judiciary if we have to truly be responsive to the needs of the citizens. So that's on the infrastructural front. For instance, recently, as a result of an order which we passed, Delhi district judiciary will be having close to 250 new courtrooms, which were the need of the hour for that court to attend to citizens' grievances. There are new judges who are joining the system, and there would have been no courtrooms for those judges to sit in. So that's something which we are monitoring. I engage very closely with the Chief Justices of the High Courts to ensure that the infrastructure of the District Judiciary and the High Courts is upgraded. Apart from that, it's important to have judges with the right kind of ethos. Judicial training is very important because judges must have the sensitivity to deal with the nature of the cases which they deal with, whether it's cases involving gender violence, whether it's in cases involving human liberty, whether it's commercial cases. If a judge is dealing with an arbitration case, they must understand the importance of arbitration in a viable commercial system in the country. So our judicial academies across India are embarking on very ambitious training programs for judges, ranging from the new recruits through the district judges to the High Court judges themselves. We have the National Judicial Academy at Bhopal, which carries out training for judges across India. And then we have the Supreme Court itself. The Supreme Court, as I said, has launched into innovative schemes for promoting access to justice. To answer your question with just 2 or 3 examples, I think legal literacy and public engagement are very important. The National Legal Services Authority, which is chaired by the senior-most judge of the Supreme Court, has been doing very commendable work in promoting legal literacy. They have launched, for instance, the Public Defender Program, which is to ensure that no person who requires legal aid in criminal cases is denied legal aid, and that everyone should have the benefit of a legal aid lawyer who is duly funded by the government, whether in the center or the states. Second, as I have already said, technology is a gateway to justice. And the third important area is judicial infrastructure in promoting accessibility.
And for that, I think the center has increased the budget of judiciary in this financial year. Still, what are the challenges ahead that you can foresee?
Well, as part of the e-courts mission mode project, I'm in fact chairing the e-committee of the Supreme Court of India, which looks after the ICT needs of almost 18,000 courts across India. Phase 3 of the e-courts project is about to be launched, and we have a budget which has been sanctioned by the Union government of 7,000 crores. And we hope that with this budget and the new phase 3 of the e-courts project, we will be entering a new phase in the ICT engagement of the Indian judiciary. My object really is to saturate. We must saturate the least technologically equipped districts in the country to ensure that citizens in these districts, particularly in the northeast and in the hilly areas of the country, have every facility that is available in terms of access to the internet. So we are setting up e-Seva Kendras. To tell you something about the e-Seva Kendras, we must admit that there is an internet or digital divide in India. Not every citizen has access to the internet or has access to the same extent as citizens maybe in some of the larger metropolitan areas would have. The object of setting up e-Seva Kendras is that we should make available within the precincts of every court establishment all the services which are provided to citizens as part of the e-courts project, so that no citizen is denied access to the normal services of our courts. And the idea, therefore, is for us to reach out to citizens through the setting up of e-Seva Kendras. We are also now, we have also collaborated with the common service centers, the initiative of the Government of India as part of the Digital India initiative, so as to ensure that the CSCs, which would work at the level of every village in India, would also provide the e-services which the judicial system provides, whether it's in terms of e-filing of cases, in access to information about their cases, about e-payments. E-payment gateways have to be incorporated and are being incorporated as part of the system. Another very important aspect which I would like to very briefly dwell on is the Interoperable Criminal Justice System, which is ICJS. And ICJS basically seeks to integrate every one of the stakeholders in the criminal justice administration: the police stations, the forensic science laboratories, hospitals, the court system, and the jails across India. And therefore, the underlying assumption of ICJS is that if we can integrate diverse stakeholders in the criminal justice administration, we'll be able to produce a more efficient system of dispensing criminal justice. There are, of course, implementation challenges, which we have to overcome. One of the challenges which we face is overcoming resistance to change from traditional paper-based systems to digital processes. Second, ensuring coordinated efforts and collaboration among diverse stakeholders, including the police, jails, the forensic science laboratories. It's not just about putting technology in place, it's also about changing human mindsets, training people. And training has been a very important initiative of the eCourts Mission Mode project. You'd be surprised to know about how many differently able citizens, citizens who have physical handicaps, are employed by the court system. We have been training them by making them aware of all the tools which are available to them. For instance, to a visually handicapped person who is a clerk in our system, who is working in the filing counters of our system, to use these modern tools and techniques so as to make them productive and dignified employees in terms of not lacking anything which somebody who does not suffer from visual challenges has access to. So we also need to overcome technological barriers, and adapting to new technologies does pose a learning curve for judges, for lawyers, for court staff, and we are encouraging judges to use more of technology. We are encouraging lawyers to use technology. The younger lawyers are extremely well versed in the use of technology. Some of the more senior lawyers, some of the senior judges, because they didn't grow up with technology. So it's work in progress. We are constantly encouraging them to adopt to greater use of technology. One challenge which I must underscore is about the need to maintain data security and privacy, because the Indian court system deals with data pertaining to the lives of individual citizens. So whether they come to court in search of a solution to their matrimonial problems, whether it's in relation to a commercial dispute, whether it's in relation to an act of gender violence, all this implicates data security as well. And this is really a challenge, and it's not something which is faced only by the Indian judiciary. The need to maintain data security on the one hand, and to ensure the privacy of citizens on the other, is a key challenge which is being faced across the world globally. And India is also engaging in finding solutions to balancing the need to have greater incorporation of technology with, at the same time, ensuring that we preserve our data in terms of both security and privacy.